The next issue which we have addressed is the challenge to Constitutional Order 273, CO 273. To answer this issue, we had to decide on two issues. One, whether Article 370 is a temporary provision, and two, the effect of the dissolution of the Constituent Assembly of Jammu and Kashmir on the scope of powers under Clause 3 of Article 370. We have held that Article 370 is a temporary provision on a reading of the historical context in which it was included. Article 370 was introduced to serve two purposes. First, the transitional purpose, to provide for an interim arrangement until the Constituent Assembly of the state was formed and could take a decision on the legislative competence of the Union on matters other than the ones stipulated in the instrument of accession and ratify the Constitution. And second, a temporary purpose, an interim arrangement in view of the special circumstances because of the war conditions in the state. C. We have held that a textual reading of Article 370 also indicates that it is a temporary provision. For this purpose, we have referred to the placement of the provision in Part 21 of the Constitution, which deals with temporary and transitional provisions, the marginal note to the provision, which states temporary provisions in respect to the state of Jammu and Kashmir, and a reading of Articles 370 and 1, by which the state became an integral part of India upon the adoption of the Constitution. D. On the second question of the effect of the dissolution of the Constituent Assembly of Jammu and Kashmir on the scope of powers under Clause 3 of Article 370, we have held that the power of the President of India under Article 370, Clause 3, to issue a notification declaring that Article 370 ceases to exist, subsists even after the dissolution of the Constituent Assembly of Jammu and Kashmir for the following reasons. First, the proviso to Article 373, that is Clause 3, encapsulates the process by which the Indian states could ratify the Constitution of India. The ruler of each Indian state had to issue a proclamation ratifying the Constitution on the recommendation of the Constituent Assembly, where such body existed. In states where the Constituent Assembly was not convened by then, the ruler of the state had to issue a proclamation accepting the Constitution. When a Constituent Assembly was convened in those states, the Constituent Assembly could make a recommendation for the modification of the Constitution as it applied to the state, and such a recommendation would be earnestly considered, into inverted commas, earnestly considered by the Union. The words recommendation of the Constituent Assembly, referred to in Clause 2, shall be necessary before the President issues a notification, as it appears in the proviso to Article 370, Clause 3, and must be read in this context. Thus, the recommendation of the Constituent Assembly to begin with was not binding on the President. Second, at the time of the framing of the Constitution of India, it was obviously within the contemplation that the Constituent Assembly of Jammu and Kashmir was formed for framing the Constitution for the state. It was not intended to be a permanent body, but a body with a specific remit and purpose. The power conferred by the proviso to Article 370, Clause 3, was hence something which would operate in a period of transition when the Constituent Assembly of Jammu and Kashmir was formed and was in existence pending the drafting of the state constitution. Third, when the Constituent Assembly of Jammu and Kashmir ceased to exist, only one of the special circumstances for which the provision was introduced ceased. However, the other circumstances, that is the special circumstances because of the situation in the state of Jammu and Kashmir, for which Article 370 was introduced, subsisted even after the Constituent Assembly ceased to exist. This is recognized by the judgment of the Constitution Bench in Sampat Prakash. Fourth, the effect of the President declaring under Clause 3 of Article 370 that Article 370 ceases to exist is that the provisions of the Constitution which apply to every state in the first schedule would equally apply to the state of Jammu and Kashmir. Articles 370(1)(d) and 370(3) were introduced with the purpose of enhancing constitutional integration and not for the disintegration. So, the power under Article 370(1)(d) and Article 370, Clause 3, even when exercised to its fullest extent, does not freeze the system of integration contemplated by Article 370, but is rather intended to enhance constitutional integration between the Union and the state of Jammu and Kashmir. Holding that the power under Article 370, Clause 3 cannot be exercised after the dissolution of the Constituent Assembly would lead to the freezing of the process of integration, contrary to the purpose of introducing the provision. And 5, if the contention of the petitioners on the interpretation of Article 370 vis-a-vis the dissolution of the Constituent Assembly is accepted, then Article 370, Clause 3 would become redundant and would lose its temporary character. The President, while deciding if the power under Article 370, Clause 3 must be exercised, determines if the special circumstances which warranted a special solution in the form of Article 370 have ceased to exist. This is a policy decision which completely falls within the realm of the executive. The court cannot sit and appeal over the decision of the President of India on whether the special circumstances which led to the arrangement under Article 370 have ceased to exist. However, the decision is not beyond the scope of judicial review. It is settled law that the exercise of executive power can be challenged on the ground of malafide. The slew of constitutional orders issued by the President under Article 371D, applying various provisions of the Constitution and applying provisions with modification, indicate that over the course of the last 70 years, the Union and the state have, through a collaborative exercise, constitutionally integrated the state of Jammu and Kashmir with the Union. This is not a case where only Articles 1 and Article 370 of the Constitution were applied to the state of Jammu and Kashmir, and suddenly, after 70 years, the entire Constitution was being made applicable. The continuous exercise of power under Article 370, Clause 1 by the President indicates that the gradual process of constitutional integration was ongoing. The declaration issued by the President in exercise of the power under Clause 3 of Article 370 is a culmination of the process of integration. Thus, we do not find that the President's exercise of power under Clause 3 of Article 370 was malafide. Having concluded that the power under Article 370, Clause 3 subsisted even after the dissolution of the Constituent Assembly, we have held that the exercise of power by the President to issue CO 273 is a valid exercise of constitutional power.